Good afternoon, everyone. Welcome to Pink Mike Leo Confessions. I'm Stephanie Garces, owner of Garces Law Firm, where we help individuals prepare for the unexpected. And today, we're actually covering a very important topic that comes up a lot. So, aside from estate planning, we do a lot of real estate, law, and this is very important because there is an intersection between real estate and estate planning. A lot of questions that we get have to do with both. So, we're going to be talking a little bit about that today, and we're going to be addressing some of the questions that I get as an attorney regarding this topic. Now, I do spend a considerable amount of time talking about people's estate plans, but we always come across the property. How do we transfer that into the trust? How do we make sure that's protected? Sometimes there's a division between real property and perhaps commercial property. There's vacation property. There's so many types of properties. So we're going to dive into different types of properties, among other things, just so that you can understand some of the questions that we get. So today we're going to be covering that. If you missed our episode last week, we did a frequently asked questions regarding estate planning in general. So I know a lot of you have asked me, what is the process for getting a will done? What is the process for putting a trust together? Do I need one or the other? These are really great questions, so I always welcome you to check out our YouTube channel or my Facebook Live page to make sure that you can see that and get more information. Now, just to kind of recap what we're covering today in case you're just joining us, as I mentioned, today's episode is called The Intersection of Real Estate and Estate Planning. Now, in general, when people are thinking about estate planning, when they're thinking about putting together something in place for their family, they almost always have a piece of property. Now, sometimes they don't. However, you still want to consider getting your estate plan looked at if you're going to be a first-time home buyer or, quite frankly, a first-time seller. A lot of stuff is intersected and it really matters. You really have to get someone experienced to know what are the different types of properties, what kind of trust I should put together for it or not. Perhaps we do something different. So I'm just going to try to answer most of the frequently asked questions that I get all the time. So the first one is, what are the most common types of properties? Now, this is a very, very broad question because there are so many properties that exist. For the first, most basic one, there's residential properties. Residential properties are where you obviously live. Perhaps it's a property where you stay with your family. You may consider whether or not it's in your name. A lot of the real estate really matters as to who's the owner on title. And what does that mean? That means who is on the deed, who's the owner. This matters when it comes to your estate plan. So when we talk about residential properties, we're talking about properties where it's your primary residence, and it could be a single family home, it could be a townhome, it could be a condo, it could be a number of things. But that's what the residential property is. Another residential property that is sometimes considered in the world of residential could be your primary residence is you could live in what's considered a trailer, or perhaps you're renting the land, but you own the trailer itself. That also matters. I know we have a lot of questions about that as well. So residential really is all encompassing, and you can think about it as your primary residence where you live every day. Now, when we talk about properties, you have to keep in mind that I just mentioned where you actually live. So if you live in a residential place, that's considered residential. This is very different than the second type of property, that is the investment property. Investment properties are essentially properties where you are the owner, but you don't actually live there. It's not your primary residence. Perhaps you rent it out to somebody, or maybe it's a family member you're renting it out to. That happens quite a lot. Maybe it's a building that has 6 or less units. That is still considered an investment property. Plenty of people have much more units in their portfolio or the real estate portfolio. I'm talking to those of you that are considered investors or have more than one home. That's considered an investment property. Those are super important when we talk about estate planning, because you have to understand the difference. And we have different plans for residential versus investment properties for a number of reasons. Another type of property that comes up a lot is commercial. Commercial properties are the ones where you are doing business there. This could be something like a dry cleaner. That's a commercial property. Perhaps you own the building. Some people will, depending on the line of work they're in, you may actually own it. For example, physicians will own sometimes the center where they do medical work. That's a good example. Also, if you, like myself, an attorney, you have other people that rent from you, but you own the actual spot, that's considered commercial. So it's essentially where people are conducting business. It's not their everyday home, but you do have tenants. That is a commercial property. You could also be renting out the commercial property yourself and still be the owner. I've seen plenty of that. That also is considered to be commercial. Another question that comes up in regards to homes is vacation homes. Those are, in a way, considered investments. However, you benefit from them because you're vacationing them yourselves. What's really popular now for vacation homes is Airbnb or VRBO. Those are all really popular and also considered to be in the realm of vacation homes that are being rented. So vacation homes in the sense that you actually live there is one thing, but people are also using their vacation homes to rent those out. So we can help you with all of that, not only for your estate plan, but also the legalities of that comes up a lot. So that's really, really popular. The other one that comes up every so often is land, just basic land. That is a form of property for purposes of estate planning and purposes of real estate. This can just be a lot. Maybe you had this lot, it's a vacant lot, there's no building on it, or perhaps there is something on it that's not a building and it's being used for something, or perhaps it's just being used for extra space. Some people have vacant lots for their own reason, and that is still considered property, and it's considered property for purposes of estate planning. So vacant lots or land, just land that nothing is on, is also considered property for purposes of the question. Another question that I get quite often is, how is property handled in a will? Now, this is a very important question because a lot of people will say, I don't know if my will covers the house, or maybe it's mentioned in the house. How does that work? Well, the most basic answer is, if your property, and whatever the property type it is worth usually over 100,000. Kind of the rule of thumb, although give or take depending on the situation, but let's just use that rule of thumb. Most properties are. Then you will consider putting together what's considered a trust to actually transfer and protect that property if something happens to you or if you become incapacitated. The idea being that the will is not necessarily the best mechanism to actually manage the property while you're living or passed away, because it doesn't actually do that for you. That's what a trust does. That's a big difference between a trust and a will. Can you mention the property in your will? Absolutely, you can. But it doesn't actually do everything that you would want it to do. For example, leaving it to a certain family member, ensuring that there isn't any dispute over it. Maybe that's the best way to explain it. So this sort of thing comes up a lot, and property is handled appropriately in a trust, assuming it's of a certain amount, and most property is, but not all of it. Sometimes if it's less, we might consider doing it another way, but it's usually handled by explaining in the document itself, which we put together for you, what you want to happen with the property. Clients will have different types of wishes with this. Some people say, I want to keep it in the family. I want it to be my grandchildren's. Other people will say, well, I want to leave it up to my children. They can decide what happens to it when I'm no longer here. Some people will even say, I want to keep this and make sure that it never gets sold until they absolutely have to. Or if it gets sold, it should be during the first year after I pass. Something to that effect. So you can really customize a trust and an estate plan. That is the best thing about it. You can really put as much as you want or as little as you want, depending on what you're trying to accomplish, in the actual estate plan. So that is really how property is handled in the most surface level information I can give you. Now keep in mind that everything is circumstantial. So perhaps if your circumstances are different than others, we may consider doing it in a trust, as opposed to perhaps some people put it in an LLC sometimes, which is a different than estate planning. It's actually business business corporation. But the point I'm trying to make is that there are different types of advice that we give clients depending on the type of property and what their goals are. So that's really how that's handled. Another question I get often is, what happens after an heir inherits the property if money is still owed? This is a great question and one that we get often. The answer to this question is, it depends on what the person who has passed away has in place. So, for example, one would think that because you're an heir, you automatically get the property and there's no issue. And even if there's money owed, we can figure that out. It depends. To be quite frank, when you're an heir and assuming the person that has passed away actually has something in place of an estate plan pertaining to the property, if money is still owed on it, there are different options. Depends how much it is. Is it a lot? Is it a little bit? That will really influence what happens. But let's say there is a property that has a mortgage on it and an heir gets it free and clear of any issues because there was an estate plan in order. Many times people will have the option of refinancing to put the property and the mortgage in their name. Now, mortgage companies do have you sign paperwork, or the people that have actually bought the house and originally signed paperwork saying that they can recall the loan. They recall the loan when the person passes away. This is something that is possible. Depending on your circumstances, it could or could not happen. It really is up to the mortgage company. So that's really what happens when it comes to that. But keep in mind, like I said, this is very specific to the facts. If the person has passed away and doesn't have an estate plan, and it is an heir, and there is still money owed, there's still a couple of options. Maybe not as attractive as the one I just explained, but there are still options. So if you are looking for that sort of advice, please let me know because I can help address those in your particular circumstance. Now, another question that I get that is pretty interesting and a valid question is it possible to divide ownership of the real estate to more than one person? So sometimes people have multiple children. Parents often want to leave the house to all of them. So the shortest answer to that is yes, that is the purpose of an estate plan. We actually customize it to your needs. If you wanted to say, I want my children to be 1/3 owners of this home equally because there's 3 of them, we can do that. So everything is customizable. It is very possible. Sometimes people will even say, well, I only want one child to have this and not divide it. We can also do the same for that. So it is possible to do. You just have to plan accordingly and plan ahead. All of this, if you notice, has to be done within enough time and with the right level of expertise, because real estate is only one of the factors that comes into estate planning, but for many, it is the biggest asset that drives the estate plan. So we can certainly help you with that. Now, another thing that comes up a lot is spouses. So if both spouses pass away at the same time, what happens to the property? This is very dependent. Again, it's always a question of, does this person have an estate plan? Does this person not have an estate plan? That is how we think as attorneys, because there's 2 different avenues that you take in this scenario. To take the first scenario, if the person that has passed away and then there's a spouse that also passed away, all at the same time, while unfortunate, if they have an estate plan in order, this can already be, we could say, taken care of. Because assuming that the person did come and see me or another attorney to do an estate plan, that property is already accounted for. The trust, perhaps, that it's in already drives the property and manages the property. The great part about that is that you don't have to worry, or we should say the heirs or whoever is outlived, the people that have deceased, don't have to worry because it's already spoken for. It's already settled into the trust, and it explains in detail what the intention was with the property upon their passing. This is a scenario where both people have an estate plan. It's all coincides with each other. There's a lot of things that happen too when 2 owners pass away at the same time. It matters how many kids there are. Are there kids? If there's no kids, who's outliving them? Do they have brothers? Do they have sisters? We really have to do a full inventory of the family. So that's like the first option that usually comes up when someone does have an estate plan. Now, sometimes families will still call us because they need some guidance in what they're doing. Just because someone has an estate plan doesn't mean we still can't be of service, because most times it's legalese. And so it's very, very tough sometimes for people to understand, what is the trust? What does it say? How do we use it? So we can certainly assist with the administration of that, or at least the guidance of that as well. So we do offer those services outside of just doing the estate work. The other option, when you don't have an estate plan and the spouses have passed away, is quite problematic. Because as I mentioned before, if you don't have an estate plan and the property is in both of your names, well, there is no one that's going to automatically get the property. Many times you have to go to probate, which happens to a lot of folks that have to go and try to get permission from the court, supervision from the court to get someone in charge of that property. So you really end up going a whole other direction. It's costly, it's timely, and quite frankly, it's a headache. However, it's necessary, and it does have a purpose to try to get everything in order and to close out the estate. And typically, this is what comes up when the person has passed away and there is no beneficiary to the properties. So really, court intervention is how that ends up. So that is really what happens if both people were to pass away, whether you have an estate plan or do not have an estate plan. Another question I get that is super important is, what are the tax implications when considering an estate plan? This is a very loaded question, because tax implications are really dependent on how much you as an individual are worth at the time of your passing. So typically there's a $4 million mark if you are worth as a whole, between your accounts, between your properties, between all of your financial information that you have that are assets. If you are worth more than 4 million, that is where there are some tax implications that are considered when putting together an estate plan. Anything below that, it's a lot more simpler, not as complex. So it really just depends on what level you're at, or what tax bracket you're at, quite frankly, and how many assets you have in place. Keep in mind that there are so many maneuvers and different ways to assist with tax implications, whether it's death taxes, whether it's taxes on the state after someone passes away. There's a lot of ways to insulate and create silos for stuff like that. So that is where an experienced estate planning attorney is a great way to try to soften the impact that taxes could have if you have the proper estate plan in order. So it really depends on where you're at, but nonetheless, there's still a reason to do it and get an estate plan in order, and currently revise it every time you get a change in your life, whether that's children, whether that's I have a new home, whether that's I married somebody. These life events are things to also consider when it comes to tax implications for an estate plan, because if you were single when you created your initial estate plan, and perhaps now you're married, you may be in a different tax bracket, which might actually trigger a new type of estate plan for you, but you would only know that if you're constantly revisiting it. So this is just something to keep in mind when you guys are thinking about your estate plan. The tax implications that come your way, always dependent on your circumstances. Now, another question I get often, and we talk about this quite a lot, is, are there any ways to avoid the probate process? I'll say that again. Are there any ways to avoid the probate process is a common question that I receive. Yes, there is a way to avoid probate. Now, specific to Illinois, because you do have to know what state you're in, Illinois typically allows you to avoid probate, not having to go to court or seek court intervention, if you have a trust to basically cover all of your things, or perhaps a will, powers of attorney, and a trust all together. So all of this matters, because when you have a will, one of the most frequently preconceived notions is that, oh, I don't go to probate because I have a will. That is not necessarily true. That is one of the biggest myths that I see in my practice. For the most part, Illinois says that if you as a person, between your home and your properties, that means cars and accounts, all of that is worth more than 100,000 and there is no trust in place to encompass those assets, you will end up in probate. Now, if your assets are less than 100,000 and you're looking at me thinking, well, I'm not quite at 100,000, I'm definitely less. Well, you may consider still putting a will together and a power of attorney to help direct your estate to put the executors in place. And remember, the will does allow for guardians to be in place. But really, the answer to this is getting a trust put together to really protect all your assets is the best way to avoid probate in Illinois. Now, it's no secret that all of this stuff that we're talking about is probably something that you may have already Googled. But one of the questions we get a lot is back to the taxes is how can I minimize taxes or capital gains for my family? Again, this question is commonly addressed with the proper estate plan. And not to mention, continuously checking in on your estate plan, because some of the viewers, you may already have an estate plan. You may have made it many moons ago. But that is also a way to minimize taxes and capital gains. When it comes to property, especially, depending on how it's set up, whether it's in your name, in a trust name, perhaps in another type of name, and what we do with the property while you're living, or perhaps when you're no longer living, also impacts that question. So having an estate plan is always a good idea because it does help minimize any sort of taxes that you could be having to pay if you didn't have an estate plan in place. But as I mentioned before, even if you have one in place, please consider looking at it because just because you have one, it may not actually encompass all of your assets that you've gotten since then. Or perhaps you have an increase in salary, or perhaps you've gotten married, or perhaps you've inherited some money. There are so many instances where taxes and capital gains all comes into play depending on where you're at in your life. So make sure you're checking in on your estate plan if you have one. We're happy to review it. If not, you certainly want to put one in place to at least consider minimizing taxes and capital gains for your family. Now, one of the things that we get a lot of questions about is what is different about transferring business or the commercial properties we talked about? Well, it's different in the sense that you want to figure out who owns this property. A lot of times when it comes to business and commercial properties, sometimes individuals will either have it in their name, they are actually the owners of the commercial property, or sometimes they'll have it in their LLC, or maybe it's some sort of corporation for purposes of liability and for purposes of protection. Because sometimes people will do that instead of putting it in a trust. There's nothing wrong with that, but typically there's a difference in that we have to make sure we know who owns it, whether it's more than one owner. That all factors into how we transfer it, which is very different than residential, because residential, there's one or two owners, maybe it's three owners. Sometimes I've seen even four owners, but the people are the owners, the individuals. Sometimes business or commercial properties, you're dealing with corporations. These are entities as opposed to an individual. While that's a great way to protect your property, there also is a reason why putting an estate plan together and assigning it appropriately to potentially a trust is a great method to protect that commercial property outside of just being an LLC. Because I think what we commonly know, and for those of you that have commercial properties or are investors, you know very well that having an LLC or some sort of corporate entity protects you. However, considering weaving this into your estate plan is a very, very important and effective way to protect your family. So transferring that in the appropriate method and even having that in your estate plan will benefit your family in the long run. So there is a bit of a difference when it comes to transferring those properties compared to residential properties because they're very different. Now, that is really all the questions that I have that usually come up as frequently asked questions. Now, I noticed that sometimes too, one of the questions I get, and I just want to make sure people are aware of this, is that people will say, should I get an estate plan if I don't have property? Because we've talked a lot about property today. Should you consider it? I always say everyone should have a basic estate plan in order because you never know when you would need it or your family will need it. There's a lot of documents that you can put together outside of a trust. For example, a will, powers of attorney, um, living wills. These are all relevant documents that can also be used when it comes to just doing an estate plan. So don't be alarmed if you think, oh, I don't need it because of XYZ, or perhaps I only need to have this type of estate plan because everyone is different. So one of the questions that came in too while we're sitting here is how do trust works regarding the ownership of real estate? This is a great question. I really enjoy answering this question because it sounds more complex than it actually is. And the reason I say that is because people think, oh my gosh, if I have it in a trust, now it's going to be a lot harder to maneuver the property, to sell the property. My ownership is going to be different. And I'm here to tell you that the answer is sort of. Really, the answer is when it comes to the trust, a lot of people will put their house in their trust. Let's just talk about residential because the ownership of it will be the trust. So you do have the ability when you put your estate plan together to protect that asset and have a trust protected. Now, on paper, the owner is the trust. And that is really an effective method. You can still sell the house. You can still do things with the house, although the only thing that comes up every so often is the refinancing that becomes an issue once in a while when it's in a trust. So that is something that is the exception to the rule. But typically the trust really just becomes the owner of the property. And the only thing that is for estate planning purposes. It's very, very important for you to consider this because again, like I mentioned before, it can help you avoid probate. It can help your family avoid probate. It can actually be an effective way to put someone in charge of the property in the event you become incapacitated or if you pass away. And it actually does a lot for your family in that it actually drives the property and really controls it upon your written instructions that you left in your trust. So that's really how trusts work regarding the ownership of real estate. And again, at the most basic level, depending on what kind of property it is, it's never a bad idea to consider putting a trust as part of your estate plan, especially if you have a portfolio of real estate or perhaps just a basic home. That is still a reason because, again, there is no way to just automatically leave the property to someone without a proper estate plan in place. And so to avoid the headache and the probate process, you may consider seeing me for an estate plan so I can kind of share my knowledge with that and see if that is the best fit for you. So I think that wraps up our Pink Mike Leo Confessions for today. As I always mention, I'm also thankful for everyone that comes and watches us on Tuesdays, 1 o'clock Central Time. If you have any questions, any concerns, any follow-up of what I mentioned today, I welcome you to give us a call. You can call or text us anytime. We are happy to give free 30-minute consultations to address your needs and your family's needs. Keep in mind that an estate plan is always an option. We try to make it feasible for all. So please don't be shy in giving us a call whenever you have any concern or any questions. I welcome you to watch me here again on Pink Mike Leo Confessions on Tuesday at 1 o'clock. We'll be covering another topic that you'll want to watch. So any questions, always feel free to reach out. Thank you so much for your time. Thank you for watching. I hope you have a wonderful, wonderful day.